All right. Hello. Good morning, everyone. Good morning, good afternoon, good evening, technology law lovers. Welcome to another session of Hot Briefings with Technology Council Foundation. I am Debashish Mukherjee, joined by my co-host Visharup Ghosh. In our
Hello.
podcast, hey, hi Visharup. So in our podcast, we speak on the strategies how to handle legal issues in technology's company with the who's who of the legal profession and professionals who work at the edge of or at the intersection of technology and law. Joining us today is Mr. R. Venkat Prabhat, who is a well-known lawyer and an advocate. He's an advocate on record at the Supreme Court of India and boasts a notable legal career with significant expertise in arbitration and litigation. He holds a degree in engineering and law and has also done or completed his executive level of the company secretary course. His career highlights include handling high profile arbitration disputes. He has appeared before various courts and tribunals and specializes in commercial arbitration, civil commercial law, and constitutional matters. Um, Prabhat is also a prolific and recognized author in the legal field and has written extensively on various legal subjects. Prabhat has successfully represented various multinational companies in high stakes arbitration, disputes, some of them including ONGC, ECL, NHPC, and NCL. He's also a senior panel counsel of the Union of India. Welcome, Prabhat, and thank you so much for joining us today.
Hi. Thanks for having me.
All right. So today we're going to talk about the something that many of the technologies companies are facing today, the challenges of enforcing cross-border technology contracts, and especially deciding what to choose as a forum or a mode of dispute resolution. Should it be arbitration? Should it be litigation? So we will delve deep into each of these and the enforcement with respect to each of these. And who better than having Prabhat take us through these.
Thank you, Debarshi. Thank you, Prabhat, for joining us. We are so pleased to have you.
Thank
Thank
you.
you very much for giving us this time.
I mean, it's a great
So
initiative. Thanks for having me. Yeah.
superb, superb. So Prabhat, see, this is a key question which Debarshi and I, in our quest to figure out what are the legal challenges and what could be the strategies to solve these for the technology companies, is what do we choose? How do we choose between an arbitration and litigation? And this is basically a question which floats around, looking for asking for the strategies around it.
Mm.
Now, before delving and going into the depth of it, Prabhat, let's start with a question for someone who is an uninitiated. So,
Mm.
how would you explain what is the difference between these two dispute resolution mechanism? What is an arbitration and what is a litigation? If you could start by throwing some light on that.
Yes. So I'll start by first of all. I mean, if when you differentiate between dispute resolution mechanisms, broadly, dispute resolution mechanisms can be painted with a canvas in which there can be amicable modes of settlement or dispute resolution, because dispute resolution is the bigger set of which adversarial method and amicable methods are a subset. Out of these methods, the out of the amicable methods of resolution comes mediation, conciliation, a combination of mediation and conciliation, and negotiations. Whereas in the adversarial system of dispute resolution mechanism comes litigation and arbitration. So litigation and arbitration, they are not actually, they are cousins. They can be considered as cousins together. They of adversarial system of dispute resolution. So in the adversarial mode of dispute resolution, more than litigation, the arbitration has facets, or it is less adversarial compared to a litigation mode of dispute resolution, because and plus it in I mean, as the Arbitration Act under the Indian courts as well as across across the jurisdictions, the arbitrators do have the power to sometimes act as mediators and conciliators. Even the Indian Arbitration Act provides aspects of it, and provides power to the arbitrator to initially aim for and try for a settlement among the parties, and he can later reduce that settlement into an award. He can sometimes push the parties to conciliate or mediate and act as a mediator in between. And if those methods of amicable resolution fail, then he can proceed to make and adjudicate an award on merits. So now comes the nuances between litigation and arbitration. Then comes the similarities. Here was the difference, and now comes the similarities. Like a dispute, like an adjudication before a court, arbitration is also an adjudication. It is before an arbitrator. In simple layman terms, one can say, because many times people confuse between arbitration, mediation, and conciliation. So in conciliation, the conciliator from his side does sometimes suggest some modes or manners, or suggests the middle path between two warring parties. In mediation, he rarely acts. He puts suggestions from his side. He purely acts as an umpire, just guiding the parties to the issues. But in arbitration, he decides an issue fully and finally between the parties, just like a court does in a public law system. So it is basically the only difference between arbitration and litigation. When they are dealing with an adversarial in the adversarial process, it is just like a court, an arbitration, but it is a private court. There are when I mean there are pros and cons and advantages and disadvantages of having a private court. What I will in this session I will explain all those issues, but predominantly the difference is only that the arbitrator can be a little more uh, less adversarial than a litigation court. But the other facets, once that amicability is over, or when the parties are truly adversarial and they want a decision or a dispute, resolution of a dispute to be adjudicated by a third party, then the arbitration and litigation are more or less the same. Only thing is the arbitration has a specific advantages owing to the specific process, and being a private court, the parties have more choice evolving the process of the arbitrator. So in those manners, there is more flexibility, but at the end of the day, the arbitration is also like a court. It adjudicates the dispute.
Prabhat, this is a very important point that you are bringing up. So you are saying that at the point when the resolution has moved on to become adversarial in nature, when neither of the parties now are intending to settle down,
Right.
and they want to essentially find someone who would preside over the decision about who basically supersedes the other, maybe where the decision, where exactly the outcome should lie for. Then there is a system where there is a private court, there is a private establishment versus there is a public system. Arbitration is where we are talking about a private court with its own rules, regulations, and mechanisms to function, but very similar to how it would be, say a public system which is there for the court. Now, Prabhat, here is my next question. See, there was dispute resolution. Litigation has always been there. Now, before getting into the merits of, what to choose, can you maybe spend 30 seconds in explaining why was the need of an arbitration? Why was there even a need of arbitration? Litigation has always been there. It has been an age-old practice to have litigation. Why was there a need of a different mode of dispute resolution?
So in fact, it flows. I mean, majorly the if you see the history of arbitration, the advantages of why arbitration as a dispute resolution mechanism gained traction is because of the international nature of the disputes. as the topic of the day suggests, cross-border, how to deal with cross-border, how to choose between a dispute resolution mechanism in cross-border contracts. That is precisely why arbitration has gained more momentum and more traction among warring parties internationally, because the inherent advantages of arbitration are, one, it is flexible, so parties don't, so when whoever has gone to court, or whoever has even dealt with the litigation courts of any country, let that alone be India, any country, of if you see the judicial system, so there is a specific rigid procedure by which it is governed. There are plethora of cases which are on its roster. The process in itself is nature, that is, you will be airing your laundry, dirty laundry, in the public, before the public at large. And here comes all the, and you cannot choose your judge who will decide your dispute. Now you may have a tech contract. In this specific example, you may have a tech contract, you may have an oil and gas dispute. Then, and he is not even, he is not graduate in the science background, he does not know anything about an oil and gas dispute. So you cannot choose your judges in courts. The roster is fixed by the system, and the case is fixed. Case is to be filed and goes to a particular judge who has that roster at a particular point in time, and you have to go before him and him only, and you have to make him understand, etc. So there is less flexibility. There is less confidentiality. Then comes you cannot choose your judges. Then there is a hierarchy of which the more of appeal option in courts. You want to restrict that. You want to quicken your dispute resolution. So all these are the inherent advantages of arbitration, which necessitated the need for arbitration as a dispute resolution mechanism.
All right. Thanks, Prabhat. I think that is very helpful in understanding the some of the advantages of why arbitration should be chosen or preferred means of dispute
And
resolution. Now, if we try,
if I can just finish my thought, one more aspect, most important aspect, why arbitration has gained over, traction over litigation, is regarding the cross-border disputes. Now, in these issues, the most important facet is enforcement. Now, in litigation, you may have a dispute between two parties, one in London in UK and another in India, and now there is a dispute between two parties. Where would you file a case? Now, you file a case in either of the jurisdictions, and then how will you enforce that in the other country? So the enforceability issue across, if you the history of arbitration generally flows from the various mercantile relations the companies and the countries had earlier. So when goods were transferred from one place to another, and still those are the predominant disputes across the world in arbitrations. So when goods are transferred from one place to another, there is a dispute, the ship gets wrecked, there is a fire on the ship, the goods get lost or gets damaged. Where will you sue a party? So sometimes the cause of action is neither in India nor in London. It happened somewhere in the seas. So that required and necessitated a dispute resolution mechanism where the parties can agree for, in transnational disputes, they can agree for a jurisdiction where they can resolve the disputes. And then comes the trust issues. Why will an Indian party trust a London court? Why will a party trust an Indian court? So these issues of deficit has resulted into this mode of dispute resolution mechanism where both the parties can choose a judge, they can choose the rules, they can choose a place which is convenient or parties, and that is how this has gained traction internationally.
Yeah. So yeah, again, like I was saying, that it's, thank you for bringing about the advantages of having, arbitration, or, what were the factors that really necessitated the requirement of having this alternate mechanism for resolution of disputes. Now, if we flip the coin and try to see from the other side, can you probably, for an in-house counsel who's trying to decide, right, whether to go for arbitration, whether to go for litigation, can you help us, or just let us know what could be some of the disadvantages of having arbitration as a mode of dispute resolution in a contract?
So the predominantly what is being in arbitration disputes is that, I mean, this is more related to strategy than anything than other than this. One is the purpose of having arbitration is it is sometimes it is cost effective. Initially, the upfront costs are extremely high in arbitration. In litigation, owing to the large pendency and the time period which it takes to resolve a litigation dispute before a particular court, that results into a cost over a period of time. But the upfront costs in high value profile cases is extremely high, especially when you, arbitrators with specific. Then the second disadvantage of arbitration is the limited appeal options. So arbitration awards are fine now. More than 160 countries, around 160 countries, last I checked, are part of the New York Convention. And we more or less follow the New York Convention. And so the awards are final and binding, and the countries have to recognize that. Plus, within the domestic scenario also, if suppose in India itself one is to consider this issue, the courts have now extremely, and that is good in one sense, depends on which side you are. So now, if suppose the courts are now heavily, they are deciding on the court's intervention should be very limited and extremely minimal. So in those situations, when an arbitrator word is full and final and binding between the parties, and there are extremely limited grounds in the various statutes across the countries, including India, it can be a disadvantage because if the arbitrator makes a substantial error, that cannot be corrected. And that is why now, suppose in India, now, I'll come to the international context, but in India, suppose for instance, the public sector companies, so owing to the bureaucratic system, actually the public sector companies actually delay a lot. There is an inherent delay ingrained in the system. Due to those delays and due to the lackadaisical approach of the system, there are PSUs lose in arbitrations. Now the PSU refraining, they have a specific irritation against arbitration system because even if they sometimes they might have a good case, but owing to delays they might lose, and if they lose, they don't have appeal option. And this happens also in technical cases, because in technical issues, even though the arbitrator may be have a particular expert in a particular field, but even then they are extremely arguable cases on both sides. And makes an error, there is extremely limited option to appeal that and to have a relook at it, because then the courts very clearly say that you cannot review on the merits, you cannot look at the evidence. So these issues, it's a big disadvantage in arbitration system. And the third, which is linked to this issue, is lack of precedents. Now, in a court system, you have set precedents available. Now, precedent system is the actual, the advantage of having precedent system is that you have a settled principle of law. You can predict interpretation. A particular interpretation you can predict by having gone through the precedents. And the lawyers and the judges also know how they can disagree with the precedents earlier set by the larger bench judges and the courts. The tribunals, owing to their private nature, they are not bound. First of all, there is no precedent system that if a particular dispute has been decided in a particular manner in a particular arbitral tribunal, the other arbitral tribunal, first of all, it's not bound by that decision. And two, it cannot access that decision. So these decisions are extremely private. So it is a double-edged sword. You have a private confidential system. At the same time, you lack precedent where you can apply similar facts to similar situations, and you have limited appeal options. So this is the biggest disadvantage of having arbitrations.
Great. I think this was very enlightening and actually very helpful for when two parties are really negotiating contracts. The fact or the understanding or weighing right on two scales whether they want a confidential proceeding or they would want to go with the traditional litigation path where they at least have a mechanism to appeal. There is a set procedure there. So I think that helps when an in-house counsel would really negotiate these kinds of terms. So now moving ahead, Prabhat, uh, does jurisdiction have an impact on the decision to arbitrate versus litigate? We see Singapore, which is a very common selected venue and seat of arbitration. Would you recommend such a neutral seat? And is there any pitfall in not having the seat at any party's place of business?
So first, I mean, I will go a little bit. I will give some nuggets for the in-house counsels regarding how to make considerations for decision making. One, not only for the dispute resolution clause and the jurisdictions, but also generally how to choose between arbitration and litigation. It boils down to, first, I mean, you have to see what is the nature of the dispute. What is the dispute that are likely to, if they are highly technical, involving complex tech contracts, arbitration might be preferred due to the ability of the parties to select arbitrators with relevant experience and expertise. Then the relationship also, I mean, if you want to maintain a positive ongoing relationship, it is better out of the two modes. If you choose between arbitration and litigation, arbitration being less adversarial, that would be preferable. Then regarding the enforcement concerns and geopolitical considerations, as well as the conflict in tech disputes, because you have a specific technology over which you have sensitive intellectual property rights or trade secrets. You want to air that publicly and discuss and those issues publicly. So then you might choose over public court proceedings, because that you might be exposing proprietary information to competitors or the public in general. Then comes the jurisdiction. So now jurisdiction is in international contracts and in cross-border contracts. Jurisdiction plays the most important role, and the importance of careful for in-house counsels or at the time of drafting of contracts, jurisdiction clause should be extremely taken care of, because that itself will decide. Many of parties in cross-border disputes are side litigation, and I mean, the maximum time is gone in resolving what is the law governing the arbitration. Now, since arbitration it's not in vacuum. Now, since it is in a vacuum in sense, because in a specific example that I earlier gave between India and London having a dispute, parties based in India and parties based in London. In this scenario, there is you want to choose a business, a jurisdiction, a neutral seat of arbitration. Suppose now in your case, what you said is Singapore. Whether can be Singapore would be a good seat of arbitration. You have to first decide what is the law governing the contract between you and the London party, or the you and the USA based company, the Indian based and the US based company. There are three laws that are applicable to a potential dispute between the parties, and this plays an important role for selecting jurisdiction, as well as jurisdiction has certain imports on the law that you are trying to apply to the dispute. So there are three basic governing the dispute between the parties and governing the arbitration. One, it is the substantive law of the contract. Now, whether the Indian contract would be applicable to the dispute or the London Contract Act or the London precedents would be applicable to the dispute, that is to be seen. That is issue that is taken care of. Then there is law governing the arbitration proceedings. What is the law that you want to apply to the arbitration proceedings? Like how arbitration proceedings would be conducted. Now, suppose for instance, in India, in the Indian Arbitration and Conciliation Act, there is a chapter 5 with a clear heading of conduct of arbitral proceedings. So generally in laws of across the country, when you choose a particular seat of arbitration, two laws come with it. The parties, the moment they designate a particular place of arbitration as the seat of the arbitration, two laws come with it. They follow. Like a vehicle, they follow the seat. One is the procedural aspect. How will you, the law governing the conduct of the arbitration proceedings? And two, the substantive law of that seat, which will be applicable to the challenge of awards, which court will have the supervisory jurisdiction over that arbitration, because the arbitration happens in a kind of vacuum. You are designating it a particular jurisdiction. So in that jurisdiction, sometimes what happens is you might require a help or assistance from the court. So in that case, the seat gets with it two laws. One, the conduct of the proceedings law, rules, and two, substantive law of that. Now, as parties, you can derogate from the rules governing the conduct of the proceedings. So, giving a specific example, when you're choosing, suppose, Singapore, once you say Singapore is my seat of arbitration, the Singaporean substantive law would be binding on both the parties. Your award would be challenged on the grounds, a party can challenge the passed by the arbitrator only on the grounds set by the Singaporean law. However, the parties can choose or modulate or deviate from the rules governing the conduct of the proceedings. So in Singapore, I am doing an arbitration. I can choose an Indian Contract Act to apply to the substantive law of the contract. And I can choose ICC rules Paris to apply to the conduct of the proceedings. So these three aspects, while drafting the clause or while choosing an arbitration clause, it's extremely important that you specify the three laws very clearly. Explicitly mention the three clauses, the three laws, what applicable to the arbitration, what would be the seat of the arbitration, and to avoid any confusion between seat and venue and the synonymous terms, you specifically mention that the courts of Singapore will have jurisdiction. Wherever you are choosing the seat, so say the courts of that country or that place will have the supervisory jurisdiction. Because that allays all the doubts. There is no doubt between the parties for potential litigation later. And so this is the very important aspect which parties miss. They mention the seat, but then sometimes they don't mention the law governing the conduct of the proceedings. And then there is a dispute because one of the parties, errant party, would always want the dispute not to get resolved and would always try to delay the proceeding. So that party will take these objections that no, Singaporean law is not the law governing the conduct of the proceedings. We had chosen some other law. We are from London, the London law to apply. They are from India. They want the Indian law to apply. So these are the confusions that take place. So it's better while drafting a contract, these three laws are very clear. Arbitration, what is the governing law of the arbitration agreement, of the arbitration proceedings, and what is the governing law of the contract. So when these three things are clear, the courts later, whenever the dispute arises, hope it does not arise, but if it arises, then you save potential lot of time in procedural litigation or procedural arbitration. Then the pitfalls. I mean, your second part of question that you said, what are the pitfalls that might that to avoid? So you'll have to see. I mean, the general pitfalls are lack of familiarity with the local laws. So sometimes arbitration laws vary significantly by jurisdiction. So choosing a seat in a neutral country, it may result in parties dealing with unfamiliar legal procedures and nuances. So this can can lead to unexpected complications, require additional time and resources to navigate efficiently. Then the increased costs. So when the seat of the arbitration is a neutral location, both parties may incur additional expenses. These include costs, accommodation for legal teams, expenses related to transporting documents or witnesses. In some cases, these costs can be extremely substantial, especially with if the dispute is complex and you know that the process will be prolonged. Then logistical challenges come with it. With cost, logistical challenges also, coordinating arbitration proceedings in the country, like supposing arranging for suitable venues, obtaining for all participants. These are basic practical issues that come with while choosing a seat. Then there are cultural and language barriers. So a neutral venue might introduce language barriers and cultural differences that could affect the arbitration. So so for this also, in international cross-border contracts, the language of the arbitration is important. That you mentioned that specifically, what would be the language of arbitration, and then the enforcement considerations. Whether the enforceability of the arbitration award can be a concern or not, you'll have to evaluate that while choosing a seat or a place of arbitration, because the New York Convention facilitates arbitration awards, but also have to see, like suppose in India and in the Indian Arbitration Act, there is also additional asset that Indian have the reciprocation agreement with that country for those foreign awards to be enforceable in India. So for
Right.
like suppose like country Pakistan may also be a part of the convention, but we don't have any reciprocating agreement with them.
You're right.
So then these are the strategic considerations which need to be taken. So yeah, thorough research has to be done, and the potential seats of legal frameworks, including local arbitration laws, the judicial system's attitude towards arbitration, enforceability awards, these have to be seen. So you need to seek expert advice while choosing. You cannot just out of thin air choose a seat of arbitration. You have to consider all these practicalities.
That's a very interesting set of points that you have mentioned, Prabhat. I mean, I want to double click on the aspect of how do we calculate. I mean, when someone is doing a contract, um, I mean, very naturally, it becomes difficult to go through each of these. It is one side, it is little difficult to go through each of these, but I think from what you have mentioned, the framework, that could get it a little easier with if someone were to follow that framework that you have talked about. Sorry. Now, I want to double click on the point. There is also a commercial aspect. I mean a financial aspect which comes into picture as to what is the kind of how do we tell the audience what is the cost of doing an arbitration. And let's take a case where there is a contract which already talks about an arbitration clause, and
Right.
then we want to we need not go into the exact figures, and I don't think that that is even relevant here to go into the exact figures. But how should one imagine that if the dispute were to move into arbitration, what all can come up as a cost? And is there any sort of an upper limit which has been set up even by the Indian courts or in the Indian judicial system, or even maybe the Indian legislature, saying that this is the kind of upper limit? Because it's clearly that even the legislature wants a lot of the matters to go for arbitration. So two
Right.
parts of the question. I mean, how do I, who is doing the contract, understand what sort of cost which can come in my journey? And second is there some sort of an upper limit, or maybe some sort of a guidance there?
Right. So, so basically, while I mean estimating costs, you need to consider that first of all, arbitration can also be of two types. It can be either an institutional arbitration, that is, you go to a particular institute like the DIAC, Delhi International Arbitration and Commercial International Arbitration Center, or you go to SIAC, Singapore International Arbitration Center. So, are institutional arbitrations. However, when you choose arbitrator by yourself, the parties choose the arbitrator by themselves, and they choose. So this is more or less ad hoc arbitration. So the costs vary depending upon one, what is the amount in dispute. first of all, you have to consider, and the biggest influence on the cost of the arbitration is the amount in dispute. So to what lengths are you willing to go, and what is the cost that you're willing to incur to justify the higher stakes? So higher stakes often lead to more extensive preparation, longer hearings, and higher costs. So you might have to see in that sense. So institution arbitrations, when you go to a particular institute, they have a specific cost structure that they will appoint the arbitrator. So when the parties submit the dispute to a particular institution, that institution will in turn appoint an arbitrator. That institution will fix a fee. So they have this elaborate charts or schedules of fees, which they have slabs. Like now, the Indian Arbitration Act also from 2015 amendment, they had brought this fourth schedule, by which a particular amount in dispute, the arbitrator can charge a particular amount of fees, and above that there are different slabs of fees that are fixed. So that similar slabs of fees are fixed for institutional arbitrations as well. They have their specific schedules. So when you submit a dispute to an institution, so you can research. So this is the thorough research that needs to be done as to what would be the cost of arbitration if I submit my dispute to a particular institution. So while drafting, so generally what happens is, once you research once, or when you choose a particular seat of arbitration, you use contracts or same clauses generally in analysis. You would have to modify and revisit those places or places of arbitration that you submit to, or the institution of arbitration you submit to. You cannot take them lightly, or you can just carte blanche paste the clauses and use them because you think about the arbitration, you consider them as the useless clauses, because at the time of entering of contract, parties don't think that they will be going to disputes. So
In fact,
this research,
in,
sorry.
yeah, sorry, Prabhat, because I couldn't stop myself. I mean, there is this. We enter into a contract, and we say that there is one particular, say, SIAC we have used, and suddenly there is a chance that that institution might have wrapped up. So therefore, I mean, that's a possible situation as well, right? I mean, I don't know if there is a solution, but you bring up a very valid point. We have to continue to look into this clause and see whether this even can actually be worked out. I mean, this can actually be operationalized. Sorry to interrupt you, Prabhat.
So that's what. So you cannot take the dispute resolution clause lightly. I mean, because that forms the major part. Because sometimes even more than the cost of the, the stakes in dispute, the parties spend in litigation and arbitration. Because once they get into that muck, it you cannot come out of it unless you the day on the other side. So you will have to go ahead and keep on fighting. And sometimes huge cost to justify that, spend more cost to fight unless a resolution happens. So that is why it is not to be taken lightly, these issues, resolution clauses. You have to keep this in mind and factor in the costs. This is one. Two, then you will have to legal representation costs. Now you can fix the arbitrator's fee by having the fourth schedule. So now suppose you can agree to a schedule like the fourth schedule, or the parties can in fact agree in their contract itself that we will be following this schedule of fees, and we will be agreeing to this schedule only, because the arbitrators also cannot fix their fee without the consent of the parties. So you can agree to those terms in the contract itself, one, or you can say that when the dispute arises, we will negotiate on this issue and come, because whether whichever party wins or loses, or whichever party is going to the dispute, at the time of paying of costs, both the parties will have to pay costs before the arbitration is finally decided. So at that time, generally on fees, paying to the arbitral institution or the fees of the arbitrator, the parties are generally ad idem. So and that agreed also. Then you will have to factor in additional cost. Then comes the legal representation cost. So you have to factor in
Right.
the complexity of the dispute, how long it can go, the length, and the jurisdiction, and the hourly rates and the fixed fee arrangements are common. Then comes the additional costs, which are generally not foreseen by the parties. Now suppose the expert witnesses. Now, in tech contracts and actually complex disputes, technical disputes, technical expertise is required, and it is generally my word versus the other side's word. So these kind of issues necessitates expert witnesses whose fees can add significantly to the costs. There is translation and
Right.
interpretation. So if the arbitration involves parties from different linguistic backgrounds or different countries, then these services would be necessary. Then the venue and logistics costs. Then comes document production costs. I mean, costs associated with managing, producing, and exchanging documents, including electronic discovery. So now in complex dispute, documents range from thousands of pages. From 40,000, 50,000 pages. I'm handling various arbitrations in which the disputes, there are 50,000 pages. Now, that is a significant cost of document production, managing those documents, etc. So then you will also have to sometimes see the counterclaims. You might have certain claims, but the other side might also go for some certain counterclaims, and those will also get added into costs that you might have envisaged. So and always also, so you might have to prepare for unpredictable costs also. That because the disputes can evolve in unexpected ways, so leading to increased costs. So it's wise to budget for contingencies. So this all boils down to extremely meticulous planning. And so, yeah.
So Prabhat, one question. When suppose a judge gets transferred, another judge gets appointed, right?
Right.
What happens in arbitration? Suppose there is an arbitrator, and God forbid, but imagine that arbitrator is no more. The arbitrator passes away. So does the whole process restarts at certain unforeseen situation? Do we see the complete cost getting wasted, and then we having to incur a new set of cost? Or
So,
is it something, if we were to
no,
go to an institutional arbitration, this gets taken care of?
no, so this is taken care of by the institutions, as well as even the statutes, relevant statutes of various jurisdictions take care of this aspect, because this is very common. Getting the arbitrator to some exigencies, if the arbitrator leaves in between, like the one you mentioned, due to bad
Yeah.
health, ill health, or death in certain cases. So the dispute does not restart from the beginning. So the statutes take care of that. In Indian Arbitration Act, if you see section 14, so there are 14, 15 talks about substitution of the arbitrator. And if an arbitrator's mandate is terminated for what reason, and then you can substitute the arbitrator, and the arbitrator will start from there onwards, unless the arbitrator requires certain hearings to be reheard. If he wants, for clarity, he wants the matters to be reheard. Generally, it happens that he takes the case from there on.
Understood. Understood.
Right.
Understood.
So now, it's kind of opening our eyes to the various different costs, right, that can be involved in an arbitration matter, and factors that actually need to be considered by counsels, instead of just blindly following the boilerplate clauses and adding arbitration. So it could be strategic from a business perspective. It could be strategic from a legal perspective as well, when you choose a certain dispute resolution method. Now, let's say there is an arbitration clause, right, in a contract. Especially in the context of India, how difficult is it to enforce a foreign arbitration award in India? And is there a way, because I think you also mentioned or alluded to the fact that sometimes when it takes a lot of time, even in the end, if you win a dispute, you may be ending up on the losing side in a way, right? So is there a way of expediting enforcement in India?
So actually, so that's what. So in India, Fortunately, the court's attitude towards enforcement has been extremely progressive. Uh, I mean, since the past of the 1996 Act, I mean, in India also the law is getting evolved, but the attitude of the courts have been extremely. I mean, there is minimal judicial intervention at the stage of enforcement, and they have been restricted to the limited grounds mentioned in Section 48 of the Indian Arbitration Act. So, foreign awards, India has been, has been complying with the New York Convention and the basic principle of New York Convention, the underlying principle of enforcement of awards should be more smooth, etc. In fact, the Indian courts have gone further. I mean, if you see, I mean, there is a latest judgment. I mean, a couple of years back, in 2021, there was a judgment of Karia, in which the courts had read that the word shall may be read as may in section 48, and they said that if there are minor issues, like suppose, for instance, the party argue that I have not been given appropriate opportunity in the arbitral proceedings to argue or put forth my case. These kind of issues, however, if or those rights or issues that you are contesting, those are subject to waiver and abandonment. They can be, certain rights are waivable by the parties. And if those issues have not caused prejudice to you or severe prejudice to you, even if there are certain issues like that, the court will still exercise its jurisdiction to enforce the award. The previous school of thought was, if there is doubt, the discretion should be to not enforce the award. Prior to 1996, and now, I mean, slowly it has evolved, and post 2015 it has evolved. So that discretion of residual discretion, the courts are now for the enforcement of awards rather than against the enforcement. Only there are extreme serious issues of lack of jurisdiction, or the arbitration itself was invalid, or the arbitration agreement is itself invalid, or certain disputes could not have been arbitrated upon. Like those major issues, unless the issue involves those major issues, if there are minor hiccups in the enforcement, the courts are pro enforcement. So in that case, it's actually encouraging for the foreign parties, and we want the aim of the government and the legislature is to make India an international hub of arbitration, like London and Singapore, to attract more international disputes to be resolved in India. We want the legal tourism, just like how Singapore has become a hub of resolving disputes internationally, not only arbitration but also commercial courts. We have taken our modeled our. I mean, we have taken the idea of commercial courts from Singapore, and we have also introduced strict timelines and formed specific benches for commercial courts in various parts of the country, and courts. We have attached benches who are specifically dealing with commercial disputes. Like that, we are taking steps towards it. Considering India being a large democracy and there are the enforcement of these aspects takes time, but we are certainly in the right direction.
Perfect. So, Prabhat, there is one question which we basically have been hearing, and there is one aspect that we wanted to touch upon. So, there is this one new and mechanism of dispute resolution, which is online dispute resolution, which is gaining a little bit of traction.
Right.
So we have got this. We have seen very recently on Shark Tank. There is this company called Sama, which
Yeah.
came up, yeah, and which came up, and they seems to be facilitating a lot of online dispute resolution. And in their own words, they are essentially trying to create or maybe resolve most of the issues out of court.
Right.
So Prabhat, I wanted to get your views on that, and what do you think about online dispute resolution, and how effective do you see it at this point of time, and can this be a future as well, apart from what are the established modes that we have so far?
Yes. So, I mean, online dispute resolution mechanism is basically a online mode of either mediation, conciliation, negotiation, or arbitration. So it is gaining momentum. Post COVID, we have seen the COVID pandemic had accelerated the adoption of digital solutions across various sectors, including the judiciary. So now we are in India. We are, I mean, slowly adopting virtual hearings, various virtual hearings, and I can attend hearings sitting here. Or case I attend hearings in Madras, or I can attend hearings in Bombay. So the to maintain social distancing and led to increase in acceptance of online hearings. So now this has led to this, plus the Digital India initiative that the government is taking, that basically it aims to transform the entire ecosystem of public services through the use of technology. So ODR fits perfectly within this framework. So it's basically offering a way to disputes efficiently and reducing the burden of traditional court systems. So now with e-commerce growth, and there is the legislative and judicial support is also in this direction, where we are trying to make the system is trying to indirectly promote ODR. So now in this case, it's basically choosing from different parts of the country. If we have, I mean, the various ODR centers are now, Sama is just one platform. There are various ecosystems that are coming up. So CADR is, I think I heard about the institution which is doing another institution well, and they are resolving disputes at very fixed minimal costs. So these, for individual disputes right now, I think ODR will gain momentum and traction very quickly, because we don't want to go to courts, and it also, I mean, there's significant amount of litigation parties approaching courts, because post pandemic people are still reeling with the effects of the pandemic and the financial losses that litigation cost is the last cost that you would like to incur. So that there is a deterrence to the litigation. The pandemic brought that deterrence, plus the huge pendency. So people are trying to reduce those costs, the entities as well as the individuals. So for the individuals, I think ODR will gain traction. For commercial entities to take this route, I think it would still take some time. In my personal opinion, it would still take some time, because even for commercial entities, they can appoint an arbitrator and agree for virtual hearings. So that will solve that problem of quick hearings. If the party is from Delhi and Chennai, they can have this arrangement, and the arbitrator can very well fix virtual hearings. So there it solves the problem of having your dispute resolution online. So, and in fact, many judges of Supreme Court judges now become arbitrators or promoting this, because they have their roster of arbitration. So they are having many arbitrations to handle. So they are preferring virtual modes of arbitration to save time of travel, etc., etc. So for individuals, I think on-right specific platforms of ODR would give traction, because the hazels are removed. You go to a particular platform, you choose the costs, you choose a particular mode, whether it is mediation, conciliation, and you go ahead with it. So that for them, I think it would be in near future, it would be a big thing. For commercial entities, I think it will still take some time.
Well, thank you very much, Prabhat. And we are just right on time. And thank you very much for that. We generally always overshoot the time a little bit, but I think with such a complex topic, I mean, you have been able to enlighten us with the nuances, which was fantastic, and also did that within this specified period of time that we budgeted for this. So, Prabhat, I would like to thank you from the core. I mean, because this is really a very interesting topic. This is really a very important piece that anyone who deals within the technology companies today, they have to constantly be weighing in. This comes into picture when someone is drafting a contract. There are these features that they would need to put in, and in fact, I would like whosoever has spent this last 1 hour with us to go back and hear back those specific points about what they need to put in the contract. Those three things that you talked about, Prabhat, that they need to have in the contract to make that enforceable and reduce the amount of disputes around that. So that was fantastic. And then the points that you talked about to estimate, how do you estimate the cost? Because it becomes an important question when any of these contracts go for dispute, to understand what is the cost that I'm looking at, because you are essentially internally, you they have a continuous tussle to figure out how do you reduce the cost and how do you quickly reach to the resolution, without spending too much of amount of money in going behind the administrative, infrastructural, all of these kind of areas.
Right.
So, coming from you, all these nuances, this was very interesting for me to hear, and I believe for both Devarshi and me, it was an enlightening session. And I hope all the viewers, listeners who had joined in and who are also going to subsequently see this session in the recorded form are going to be immensely benefited out of it. So, thank you very much, Prabhat.
Thank you so
So
much.
we would be closing the session now. But before we do that, as we do it every time, so there are two things that we want to bring to the bring before the view of the viewers, listeners. Number one, a course which is happening at IIT Kharagpur on artificial intelligence and law. It's has been designed in collaboration with the Technology Council Foundation, and it's going to happen on 6th and 7th of April on campus, along with 13th and 14th of April on the hybrid mode on online. So whosoever wants to join in, whosoever wants to register, head on to the Technology Council Foundation's LinkedIn page, look at this pinned post, and you will find the way to register. That is number one. And second is, we definitely have continuous flow of hot briefings, legal tech open mic, and further things which are coming up. Uh, for the hot briefings, you can expect to hear from us nuances of how ESOP, RSU, ESPP work when we come back next time. So we want to leave you with that hope that we are going to come back and speak to you again about this one key issue of how should compensation work for technology companies and how these nuances will work. And again, thanking you, Prabhat, thanking
Thank
you, Debarshi, closing it off for
thank
today.
you. Thank you for having
Thank
me.
you very much.
Thank you so much. Thank you.